comment in any way.
You mentioned before that the Press Council wasn't as well known as the Broadcasting Standards Authority. And maybe that's because the Press Council doesn't have the teeth that the Broadcasting Standards Authority has. With this new body, it's really not going to have teeth at all in terms of penalty. Isn't that a problem?
That's why we did consider financial sanctions, but in the end ruled them out, because we think that media, if it's made public that it's gone wrong, that is a sanction in itself. But also things like takedown orders, rights of reply, corrections, that's a remedy for the person. We don't look at those so much as sanctions, but what's wanted here is a remedy for the person who's been aggrieved. We have suggested, by the way, that this whole system should be reviewed after it's been in operation for 1 year. So if you turn out to be right, and this is still insufficient, we may have to be a little bit of ramping up, but we think at the end of the day, there's enough here. And I think the main reason the Press Council isn't quite as well known is that the BSA is required to announce its presence, and broadcasters are required also by law to make the BSA's presence known as they broadcast. People have to be told they have the right to make a complaint. With the Press Council, that's not necessarily so.
You said it will be reviewed after a year. Do you expect most of the provisions, though, to have a decent longevity in the face of advancing technology? Looking at the past and technologies that have come up, do you see the danger of something coming up that you can't deal with?
I mean, the whole trend of law reform these days is trying to keep up with technology, and of course you can't predict what's going to happen. But this is as forward-looking and as technology-neutral as we can make it. But if in the long term we haven't thought of enough things, it'll have to be revisited. But what we've tried to do is to say convergence is the name of the game, new technology is the name of the game. This is what we need to deal with, a single converged regulator, which will have to cope as time moves forward. So, yeah, you certainly can't predict everything that's going to happen. I think we've gone about as far as we can at the moment.
How do you see Twitter playing into all of this?
Not much. Twitter I would not regard as a news medium at all, really. Twitter is just, it's one of the social media. And that's far more relevant to the second part of our report that I mentioned. And if people by Twitter do real harm to other people, that's something a court may have to take account of.
Do you think that's ignoring that technology because it's a viable source of information for a lot of people at the moment?
It's certainly a starter, but I think our answer would be if you just use Twitter and nothing else. I don't think most people would say, I'll just depend on Twitter. They would say, let's check it from one of the main sources.
What about journalists' tweets?
Stephen, you're raising some good questions. The question is, our definition is it's a medium which broadcasts news, that's to say factual material, on a regular basis to the public. And if there was a journalistic tweeter who was doing that on a regular basis, you might argue, yes, they are qualified to belong to this, and they could apply to.
Most just about every news organisation actually does broadcast regularly on, publishers.
Yeah, and that's fine.
On Twitter.
Yeah, and that's fine. I would say that comes right within it. But it's the individual who's the occasional tweeter, that's much more on the borderline. And if you get marginal cases like that, IMSA would have to decide on an application whether that person should be in or out. And there will be borderline cases, sure.
So just to clarify, if we're tweeting here, that would count under...
I don't see why it shouldn't, because what we're saying is platform doesn't matter. It's the fact that the news is out there. Are you tweeting from here, by the way?
There's a gentleman on a page.
So yes, I think that would be within it. Yeah.
Yes. John, why is it necessary to suggest the withholding of New Zealand money from outfits that don't belong to the new body? I mean, that is a form of a financial penalty.
Yes. Well, currently, I think I'm right in saying that it's mostly production companies that apply for the funding, and there's a contract now, as I understand it, with New Zealand On Air, which states that they have to show that they have got a broadcaster subject to the BSA. So we're simply trying to expand that to the new system. So I think we're doing a little more than expand what's already there. It wouldn't be a statutory requirement. It's a suggestion to New Zealand On Air that that's the kind of requirement they might impose. But they can give money on any condition they like.
You described it as kind of a brand advantage for the group that media outlets do sign up. If they're not convinced by that, they don't. You end up with a two-tier visa, would you? That's not what you want.
Correct. So there are two alternatives. One is to do nothing at all, and the other is to compel everyone to belong, and we're very reluctant to do that, because we think that's just against the whole tenet of freedom.
Your report talks about journalists being defined, or news media being defined as, among other things, people who sign up to a code of ethics or a complaints body.
Yeah.
And in some parts of the report, it seems to leave that open for it not being the one that you're particularly setting up. So it might be an alternative one that somebody could set up and therefore be a journalist, but be outside minister or whatever it is. Is that what you had in mind? There's another part of the report seems to suggest it has to be
not really. In the early stages, we're trying to define what news media means, just in general terms, that it must belong to a complaints body. We then go on to say that in our view, that complaints body ought to be NIMSA.
And under this definition you're proposing of a journalist, it must be NIMSA. So I can't say, oh, I'm a journalist, I've got my own code of practice.
If this comes about, no.
Do you
And
think-
see, if that was the case, you could have a whole lot of regulators again, building up just a plethora of people doing different things in different ways. So to make any sense, for consistency's sake, we think there's got to be one.
Bodies like, say, the Law Society or, you know, a union newspaper that produces news
Yep.
in a specialist field, or even a commercial website that claims to produce news, do you see them being able to join?
Yes, if they want to. I imagine most of them won't. But if they want to have that brand, why should they not do so? See, the fact it's a choice means a lot of these bodies will decide not to, as they have a perfect right to do. So they'll be asking, what's in this for us? And do we think we'd gain a brand advantage from doing so?
The Press Council requires complainants to sign a waiver to say that they won't take litigation.
Yep.
Would you see that the new body, you know...
No, I've always had doubts about the propriety of that. No, we wouldn't do that. That's taking away a right of access to the courts, which is a pretty fundamental right, it seems to me.
So you would want to discourage people from turning up to a hearing with their lawyer?
We think this kind of complaint system is one which ought to operate as simply, as quickly, as efficiently and as cheaply as possible. And that's why we say if there can be a mediation service attached to it, that could be a great advantage, because matters which have the potential to escalate could be covered at the pass. Not all of them will be, nor can they be expected to be, because if you go to court, you know, if parties are entrenched in their position, sometimes it does end up in court depending on it.
So the mediation would only be for things that might get to court. You wouldn't have mediation of a fairness complaint, for example.
Well, you might, but we're talking here particularly about people alleging legal wrongs, breaches of defamation or contempt. Defamation, privacy would be the two main ones, where it's really escalating, and if that can be stopped at the pass and a simple, acceptable solution reached between the parties, that's a good thing to do.
At present, the Press Council rule is that you don't actually renounce your ability to sue, but that's certainly the condition upon which you engage with the Press Council. I mean, it's probably not enforceable, but mediation would seem to be less of a protection for media from defamation action than the current Press Council regime. That would potentially be an obstacle, I would imagine, for newspapers.
Well, mediation doesn't have to work, and if the parties can't agree, it doesn't work.
Well, the main problem is that it costs money, though. The main issue for everybody is that it costs money.
Have already made that point. And one way of solving it may be to say that some of the adjudicators who are on your complaints panel could serve as mediators in a case, of course, in which they were not adjudicating. And you may be able to get people expert in the business who could just sort things out before it gets to an extreme pass. But the huge majority of cases will not be like that. They won't be things that will proceed to court anyway. They'll just be ethics complaints. You know, inaccuracy, lack of balance, opinion masquerading as fact. And these are things you can sort out by simply deciding the complaint. So mediation won't apply in very many cases.
There's been a significant lack of mention of Australia. Did you consider what they have decided to do, or rather not to do?
Yes, Sir Grant made the point that we have to look abroad and see what's happening there. And we don't think what's happened there is suitable for us. We are a unitary, simple jurisdiction where I think we can be a little more inventive than they've been. And in Britain, of course, in the Leveson report, all Leveson was looking at was the newspapers. And he was not asked to look at convergence at all. So his, in a sense, deals with a very small part of the problem.
To some extent, I think Finkelstein was somewhat influenced by our issues paper too. Certainly he referred to it. But I think you're maybe better placed to answer this than I. I think to some extent there is already a certain degree of regret in the United Kingdom that Levinson was so sharply focused. And of course it got people's backs up in a pretty extreme sort of a way. Admittedly, the matters that we're dealing with were troublesome and even an extreme, but one of the things we hope about this one is that we're trying to provide a flat platform that can go forward, it can be further developed without that, without the sharp edges that were involved in the United Kingdom by the very nature of the things that Levinson had to look at.
And on the Australian one too, both the Australian Convergence Review and Finkelstein did assume that statute would play a part in it, and there would be an element of compulsion of some bodies, and we've tried to avoid that. And that, I think, was one of the sticking points that would be.
Have you had any feedback yet from the Press Council or BSA or industry?
We have kept them informed as we've gone. Feedback as to how they'll respond, no, not really. But they're fully informed as what we're doing.
Just on that, of course, by governmental feedback, of course, the cyberbullying proposals, which are part of this, are clearly advancing. As you know, the Minister, well, really it started at the PM's office, but the Minister's made it plain that they are advancing. So whatever else happens, that sub-part is well underway.
You see the two sets of regulation, sanction, whatever you call them, against cyberbullying and the convergence of broadcasting. Do you see those crossing over at all?
The only link is this: we are saying that as far as cyberbullying goes, if you're a member of NIMSA, you're not affected by that reform. So NIMSA is expected to do the job, but if you elect to stay outside and you hurt somebody by cyberbullying, then the new arrangements for digital communication harms, which include a special tribunal and what we call an approved agency, that will affect you. So it's one or the other. So, but apart from that, there's very little crossover. Because by and large, the media, the responsible media, don't cyberbully people. Even though occasionally we might be inclined to think that they would, but they don't.
So this relates to organisations rather than individual journalists. At the moment, the privileges which are applied to individual journalists are actually applied to the individual journalists in their own capacity, including exemption from Privacy Act. And so how would you address that?
If you're an employee of an organisation, you take the organisation's privilege, but if you're an individual journalist who fills all the requirements, it could apply to you individually. Yeah.
So that will just be in terms of the NMSA's guidelines?
Yeah, yes. You can use the broad term agency, if you like, and so it could be either an individual or a corporate body.
Because, I mean, the problem, I mean, you're going to put NMSA into statute via some omnibus bill which is going to make a whole lot of stuff, requirements.
No, just a wee schedule. No, nothing like that.
But including Privacy Act?
Oh, yes, but all it will say is in this Act, when the news media are exempted, we define news media as media which are subject to NIMSA.
But how does that apply to an individual?
Well, you can be, if you're an individual journalist doing your own thing, you can join NIMSA.
Right.
What if you're a documentary maker or a book author or a trade publication, and therefore either you're not publishing regularly or you're not publishing public? You can't go into the state.
No, that would be right, but you then have great freedom to do as you like, to say anything you like.
You won't get court access even if you're writing a book or doing a documentary on.
Well, the court does have an overriding discretion to admit other people, and I think you'd have to approach the judge, but you'd have no right to be admitted, as I say, as I read.
Well, you don't have any right at the moment, it's up to the judge, isn't it?
No, currently, if you belong to the media, whatever that means, and in the Criminal Procedure Act it means either Press Council or BSA, you have a right to to stay.
Right.
How much?
It's worth joining us.
How much can members expect to pay to be a part of NIMSA?
I have no idea.
Do you have a ballpark estimation or?
No. That's something we recommend the working party would have to look at. And I don't currently know what press members have to pay to join the Press Council.
Well,
I
members,
don't know.
Some members who accept jurisdiction of the Press Council don't pay, like NBR.
Yes, and that should not be allowed to continue under the new system.
So you haven't got an idea of how much the government will put into this either?
No, that's a matter for negotiation. We didn't want to get too far into that sort of detail.
Do you think this is going to confuse people about who to actually complain to?
No, it will simplify.
So, if I'm watching a documentary on television, which is a factual program, do I go to the BSA or do I go to the NIMSA?
If this all comes about, the BSA will no longer have jurisdiction over that sort of thing.
Okay.
There'll be just the one body, the NIMSA.
Okay. So if I saw something on the news, I'd go to NIMSA. If I was watching Outrageous Fortune and there was something I didn't like, then I'd go to the BSA.
Outrageous Fortune I would regard as entertainment of a certain kind. I don't think it's a news program. But there will be some awkward lines to draw, I quite agree with that. And then the entertainment body, which currently is BSA and or the chief censor, would have to make an arrangement with NIMSA as to who dealt with it, one or the other.
Did you think about creating an authority that, you know, it covered all of those things rather than just using current affairs? So it's just like a one-stop shop for everything rather than just news?
We did, and in the very long term that could come about, but we just think that entertainment is such a different thing from news, because news is all about democratic information flows, enabling people to be good citizens, and also really holding government and our institution like the courts to account. And that's a very different function to one entertainment, like Californication, for example, does. But that's a different matter. That's fun. But you see what I mean? I agree it's a very hard line to draw, and I think some of the television producers now would say that what they call factuals, which are things like, you know, Piha Rescue and road cops and that sort of, they would say they're entertainment. But we would argue, I think, that because they purport to present facts and they involve real people, there could be some real journalistic issues there. And we'd say, under our very broad canvas, that they are news.
So it's like the news and documentary?
Yeah, exactly. Yes, exactly. And commentary on news, which is Campbell Live and Seven Sharp and that kind of thing.
Well, broadcasters are going to prefer things to be news because there's no monetary penalties.
Yeah, that's right.
So does that mean the BSA can't hand out monetary penalties anymore?
It will retain, until there is a new entertainment regulator, the BSA will retain control over entertainment. So it could, yes. But, you know, for straight news, if what you're complaining about is unfairness or inaccuracy or failure to separate fact from opinion, I'm not sure that monetary penalties are appropriate, really. What you want is to put it right. A clear statement of this is an incorrect statement that's been published, and let's put it right. And it's the remedy for the person you're looking for, I think. Whereas if you are publishing obscene material or something like that, that's a different matter altogether. There's child protection to be considered there. And I think the state's got to be involved in that, and that's a different matter. And that's not our concern. Because we were asked to look at the news media.
What about costs?